Okay, I want to thank you all for joining us. There'll be other people that will be coming online, and this is a program on the important issue of SB147. It's a proposal in Texas Senate to prohibit citizens and government entities from 4 countries, China, North Korea, Russia, and Iran, from purchasing property in Texas. Proponents say that the measures protect Texas security. Opponents point out similarities to the alien land laws that targeted people because of their race. My name is Ted Gong. I'm the executive director of the 1882 Foundation. 1882 was the year the Chinese Exclusion Act was passed. Our foundation is nonpartisan, nonprofit organization that broadens public awareness of this act, its continuing significance to all Americans, and about Chinese American history and experience. We carry out this mission objective through programs that include monthly talk story events, such as this webinar, in which we have partnered with UCA and APA Justice. This is the second discussion of this topic. We will be looking at SB 147 largely from an historical perspective. For that, I'm happy to have with us the expertise of 4 good friends and scholars, Jean Wu, Janelle Wong, Madeline Xu, and Carol Suzuki. Before passing the moderating role to Janelle, I do want to say that this webinar is being recorded. It will appear on YouTube in a few days. So although we have muted all but the speakers, you may want to confirm that your mic and your video are off. But of course, we encourage you to use the chat function to ask questions and make comments. Stephen Pei and I will be monitoring the chat and passing the questions to Janelle. And we will also have, hopefully have some time near the end of the hour to open up for Q&A. Janelle Wong is Professor of American Studies, Government and Politics at the University of Maryland. She is a frequent guest commentator on issues affecting Asian Americans, and she will introduce Jean, Madeline, and Carol.
Thank you so much, Ted, and thanks to the 1882 Project for your tireless efforts to bring our stories to the public with these really wonderful opportunities to be in conversation. I wanted to introduce our speakers. Jean Wu, attorney and Texas State Representative and former president of the Houston 80-20 PAC. Madeline Xu, who is the Mary Helen Thompson Centennial Professor in the Humanities and Professor of History and Asian American Studies at the University of Texas at Austin. And Carol Suzuki, who serves as the Kaler, I'm sorry, Carol, you may have to, I had a little typo here. You may want to introduce this again. Kaler McLeod Professor at the University of New Mexico School of Law. Carol, do you want to just say your chair's name?
Keller and McLeod.
Keller.
Yes.
Okay.
Thank you.
Okay, sorry about that. Keller. All right, so let's get going. Thank you again for being here. And we'd love to have Jean Wu do some kind of big picture table setting, giving us a description and, oh, wow, a lot has been changing, a status update on this legislation. I'm going to turn it over to you, Jean.
Thank you so much, Janelle. It's a pleasure to be here. I wish we were together under better circumstances, but this is something that our community's been dealing with for quite a while now. So just the short of it, in case you're not familiar, this is a legislation that's been filed in the Texas Senate that directly, basically states, or not basically, but it does state that immigrants from China, Russia, Iran, North Korea would not be able to purchase property in the state of Texas, at least until they became United States citizens. So I think the rationale that's being pushed forward by the authors is that it's a matter of national security. They're trying to keep adversarial countries from owning property in our state. And the problem with that is that when we acknowledge that there are real national security concerns considering China and Russia, but the problem is by tagging all immigrants from China, right? We're basically saying all immigrants from China are possible spies and traitors and are here to harm our country. And those are really dangerous things to say, especially after 3 years of unprecedented rise in anti-Asian hate. And this is going to put a target on the backs of our community. And especially this type of legislation is especially painful because, again, we've already done these type of bills before, and for the exact same reasons. So back when it was the alien land laws, we prohibited Chinese and Japanese people from purchasing property because they were untrustworthy. They were threats to our security. They were threats to our society and our culture because they're too strange and they're too weird, and they speak weird languages, and they eat weird food, and we don't need them around here. And I think in terms of like as late as World War II, and I talked about this in all my interviews, is we had a U.S. government that recognized that German Americans, people with German heritage, were not responsible for what was happening in Germany, and only about 10,000 German nationals were rounded up during World War II by the United States government. But our country looked to the other side and said, well, there's something inherently different about Asians. There is something inherently untrustworthy about them. We don't believe that they're truly loyal to our country, even the ones who are American citizens. We don't believe that they could truly ever be American. And so instead of following the same practice as they did with the German Americans, our government rounded up 120,000 Japanese Americans, like 60% of whom were American citizens. And this idea that there is something inherently untrustworthy about being Asian, that we can never be loyal to this country, we can never truly be American. I think that's at the heart of this, because that's our main consideration with this type of legislation, because there are ways to address national security, and we've seen this being addressed in like states like Virginia that passed a bill that did not single out countries and that only targeted government actors. And we have a bill in the House, House Bill 1075, that only targets government actors and government agents and leaves individual people alone, and does not, and in a blanket statement, say that all immigrants from China are suspect, just by the nature of being Chinese, of where they were born.
Thank you so much. And to help us dig a little bit deeper into this history, I'm going to ask Madeline Shu, can you please help us to better understand the historical context that Jean was sharing with us? For this kind of legislation, the state legislation that's related to nationality and property ownership, or nationality and other kinds of security policies.
Thank you, Janelle. I want to thank the 1882 Institute for organizing this event. I'd also like to thank Representative Wu for being in the thick of the political situation here and sort of being such a strong advocate on behalf of the Asian American community. Your leadership is deeply, deeply valued and appreciated. So I'll start by saying that alien land laws, restrictions on property purchases, such as SB147 is proposing, have a long history in the United States. As early as the 1850s, the state of Oregon had enacted alien land laws. The most powerful and most replicated were the alien land laws enacted in California in 1913 and 1920. These alien land laws took advantage of legal and ideological discrimination against Asians. So for most of US history, from 1790, which was when the first nationality law was passed, through 1952, Asian immigrants were legally barred from applying for citizenship by naturalization. They were, and the original framing of the law was that only free white persons could gain citizenship if they had immigrated from elsewhere. This was held up in court. It was used to create a legal category called aliens ineligible for citizenship. And this came to be a sort of shorthand for foreign-born Asians, Asian immigrants, that was then actively used in different kinds of laws to restrict access and opportunities, sort of employment for foreign-born Asians. The earliest targets actually were Japanese. Japanese immigrated to the United States with this ideal that they would come and they would emulate the classic trajectory of European immigrants, that they would go into farming, they would get their own farms, they would develop them, they would sort of help to develop the sort of different areas of the United States. And, you know, and also to show that they also could be just as accomplished, just as hardworking, just as driven, and participate in the United States in this way. But the key difference was that they were Asian. And the United States was openly segregationist. We don't start having more dismantling of institutional segregation justified by the Supreme Court decision of Plessy versus Ferguson in 1896. That doesn't start happening until World War II. And so we have to recognize that alien land laws are part of a bigger picture of racial segregation. These days, it can no longer be on the basis of this category of aliens ineligible for citizenship. The racial restriction on naturalization was finally ended in 1952, but the targeting of populations on the basis of national origins is today's version of this. And, you know, and as Representative Wu has already been talking about, national origin is a extremely dismissive and prejudicial way for identifying, for categorizing, you know, persons who are sort of active representative, active agents on behalf of a possibly hostile government. And it then really victimizes people who are just coming to this country. They are just trying to seek out opportunities. They're sort of becoming parts of communities and neighborhoods. They're just simply seeking a better life for themselves. And these kinds of legislation that are claiming to mark out hostile and dangerous persons on the basis of their nationality and citizenship, in fact, are not effectively achieving that goal, while institutionalizing, rendering into laws these kinds of prejudices and sort of deeply, deeply racialized and hostile perceptions of, in this case, Chinese and North Koreans and Iranians and Russians. So I will stop there. I'm sure Carol has a lot to say as well, and then we can get questions later.
Super. So I am going to turn it back to Representative Wu for our next question, and just to provide some clarification, which is, Representative Wu, there are some recent developments, and I see this coming up in the Q&A, announced today that this Texas bill will be modified to remove restrictions on home buying, that is, home purchases would not be part of the law, and whereas before, in the original version of the law, any Chinese or Iranian or Russian or North Korean non-citizen would be subject to restrictions, it will be modified now. That's what has been reported, so that there are no restrictions on permanent residents or dual citizens. One question that's coming up is, what about H-1B holders? And another is just, can you help us to understand the current political climate and the political dynamics informing this discussion.
So one of the things to note is part of the reason why they're making changes now is because the community has been so vocal in pushing back against this legislation, which is like very good. I mean, like I think that's one of the bright spots in this, that our community has really stepped up and really united to fight this off. And I think we should all be very proud of it. But and we knew that they were going to do something like this, but at the end of the day, we're still running into the same problem. Even if you cut out green card holders, even if you cut out dual citizens, and you're still just doing visa holders, which would include HB1 visas, which include EB5 visas, which include F1 or student visas, any number of situations, including refugees, including people who are actively fleeing North Korea, fleeing Iran, and are coming here under political asylum. Again, this is sort of the irony of punishing people for the actions of the governments that they actually are literally fleeing with their lives from. It seems sort of unjust. But at the end of the day, whether we have green card holders within this bill or not, it still is the problem of you are blanketly taking a population and saying that they are a threat to our nation. You're restricting their rights, and the basis of restricting their rights is where they were born and where they come from. And that is inherently discrimination based on national origin. And again, we go back to the same thing that we talked about at the beginning, is this concept that there's something untrustworthy about Asians. There is something inherently sneaky or fraudulent or suspicious about people of yellow skin. I think this still plays into that. This still has this idea of we have to pop every visa holder, every immigrant until they get a green card. We can't be sure. It's the same thing. It doesn't change anything. And again, it's not like we don't know how this could be different. If you want to deal with national security, if you want to address those problems, there's ways to do it. And we have seen other states address it in a way that is not demeaning and discriminatory. And we have it filed in the House side of, you could have a bill that just targets only the government and only the government of those countries, and targets, it doesn't list out any country, and just say like foreign governments can't own property in the state, and if you look at the additions, the changes that they've made in this bill, they included things like mineral rights and timber rights as real property. What does that have to do with anything? Why does mineral rights have anything to do with national security? What does timber have to do with national security? At the end of the day, if you look at this and you look at it carefully and you stop listening to what the bill authors are saying, it almost just sounds like we don't want Chinese people, we don't want Asian people owning property in the state. And, it's hard to ignore that.
Thank you so much. And I wanted to take it in a slightly different direction, because we have an expert here who worked with students to remove an Alien Land Act, very similar in spirit to this one, in New Mexico. And so I wanted to turn to Carol Suzuki, a law professor, to give us a brief history of the Alien Land Act in New Mexico and the work that you did with your students to remove that law from the books.
Thank you so much, Janelle. I'm thankful for the opportunity to speak today and participate in this webinar. SB147 is a troubling symptom of long existing and increased racism and xenophobia in the United States. So let me start with telling you a story about the impact of the alien land laws on my family. I'm Japanese American. born in Los Angeles, California. My paternal grandfather was Japanese and came to the United States to make his fortune in life. He was a farmer in what is now downtown Los Angeles. He organized a celery collective to help his fellow farmers and community to prosper. He was not able to own land as he was not a US citizen and could not become one, so the California alien land laws prohibited him from owning land. My father was born in Venice, California, but he moved to Japan with his parents when he was very young. My grandparents decided to move back to Japan in part because of the California alien land law. My grandfather understood the limitations to his success because he could not own the land that he farmed. So now I'm right next door to Texas and New Mexico. I have taught at the University of New Mexico School of Law since 2003. The mission of UNM and the law school is to provide service to the New Mexico community and promote justice. And it's one of the highest ranked clinical law programs in the country. UNM is one of the first law schools to require that every law student take a class where students take a course where they get practical experience by representing clients and entities in legal matters. Students under my supervision provide New Mexico residents with direct legal services, and they also engage in projects to enhance New Mexicans' quality of life and advance our collective understanding of cultures and the world. The original New Mexico Constitution that was drafted in anticipation of the territory of New Mexico joining the Union guaranteed that there would be no distinction between resident aliens and US citizens regarding ownership of property. The territory of New Mexico was admitted into the United States in 1912, becoming the 47th state. However, the constitutional section was amended in 1921, is driven by concerns among the native population regarding an onset of Japanese immigrants. Article 2, Section 22 of the Constitution of New Mexico was revised to state in part that no alien ineligible to citizenship under the laws of the United States shall acquire real estate in New Mexico. So essentially, no person who could not become a US citizen was able to own land in the state. And this provision was directed at Asians, primarily Japanese, who were not free white persons or persons of African nativity or descent, and so they could not become naturalized citizens under the federal immigration laws at that time. In 1952, the United States Supreme Court found that alien land laws violated the 14th Amendment of the United States Constitution, but the alien land law remained in the New Mexico Constitution as a reminder of our racist past. It was overcome to some extent in 1975 with respect to state law when a law was passed in New Mexico probate code that allowed non-citizens to inherit and own land. So no state barrier remained to non-citizen ownership of real property in New Mexico. But that Alien Land Act was really a blemish on the state. And at that time, we shared the distinction with only Florida to continue to have such an offensive and exclusionary provision on the books. When I came to UNM, I learned about past unsuccessful efforts to repeal the Alien Land Act, and I undertook the effort with clinical law students to get rid of that provision. Because the alien land law was in the New Mexico Constitution, it could only be removed through vote of the people. A referendum to allow a vote died in the House on the House floor on the last day of 2004 legislative session, but undaunted, we continued, and the next year in 2005, Senator Cisco McSorley introduced Senate Joint Resolution 10, which proposed to repeal Article 2, Section 22 of the Constitution of New Mexico in order to protect the right of all persons to acquire and possess real property. The law students then worked to educate state legislators about the resolution and gather support. The resolution was passed by the legislature, and so therefore that issue was placed on the referendum at the 2006 general election ballot to allow voters to decide whether to repeal the racist provision in the Constitution. And on November 7th, 2006, New Mexicans voted to repeal the constitutional section, with the vote being around 70% yes and 30% no. So we edged out Florida in repealing our state Alien Land Act. Florida first made an attempt in 2008 and then successfully was able in 2018 to repeal its Alien Land Act. So in 2018, no state law remained that was an Alien Land Act. These attempts in Texas and other states to legislate hate and xenophobia, it's frightening, and you can see it's a step backwards. So this is very troubling for our nation. Thank you for letting me share New Mexico's Alien Land Act history with you today.
Thank you so much, Professor Suzuki. This is such a critical topic, and it's, I think, really important that we look to other places of advocacy, you and your students, and the work that Representative Wu has mentioned about those in Texas and all over the nation really pushing back at this legislation. There are some questions that have come up. One is, how do nationality-based restrictions on property ownership, what's the theory here in terms of how they might protect national security? What's the logic?
I mean, I'll do my best to try to answer in their place, but I mean, frankly, for me, I'm not completely clear, because in 2021, we passed a law saying that that foreign governments couldn't, and companies connected to foreign governments could not own critical infrastructure, meaning water, power, telecom, and things of that nature. And that made sense, and it was very limited in scope. But to go from something that was very limited and only affected a few types of property, to go from that to a bill that affected all property, every residential property, every commercial property, every agricultural property, the justification is frankly, I don't understand. I don't understand the justification. But some people have said, like, look, food security is a real thing, so we shouldn't allow these governments to own farmland, because it might change food security. Now, granted, like the Chinese government owns some farmland, but of all the farmland owned by foreign governments in the United States, it's less than 1% of those farmland owned by foreign governments. And in terms of residential property, and now that they've taken residential property out, but in SB 711, which is a bill that we didn't notice until recently, that bill also includes all property as well. What is someone's house? What is the house that I grew up in, that my family bought when we were waiting for our citizenship? The $60,000 little crappy little house that my parents had. What does that have to do with national security? I don't know. And people keep telling me that it's about national security, but like no one has been able to explain exactly why. And some people just say, well, we don't want to let them have a foothold in the country. I'm like, I don't know what that means, because Iranians have no diplomatic relationship with the United States, and neither do North Koreans. There are no North Korean government officials or Iranian government officials in the United States. They don't exist because we have no diplomatic relationship with them. The few lands that Iran did own before the fall of the Shah have all been confiscated and sold off by the U.S. government years and years ago. So if you want to say it's national security, somebody needs to tell me why. I mean, I understand the concept of national security, but what does the individual immigrant have to do with it? what does a piece of a soybean field have to do with it? What does you know, some property on a strip mall have to do with it? And realistically, you know, I think it's one of those things that when we were talking about public policy is when the stated goals don't match up with the action, then you go, huh, that's really interesting. That's really curious. So maybe there's something more to what they're doing if what they're trying to do and the way they're going about doing it don't match up.
Thank you so much. Does any other panelists want to just chime in here?
You know, I could give the historical example, and this goes back to the incarceration of Japanese Americans. The official justification for this mass violation of their civil rights was military necessity, right? And that principle still stands to this day. There was these sort of these claims that you know, to within 100 miles of the Pacific coast was vulnerable to Japanese attack, bombing, such as happened at Pearl Harbor, and that if you allowed persons of, you know, of Japanese descent, right, and this, and as Representative Wu said, this included 2/3 U.S. born U.S. citizens, that they could not be allowed to sort of remain on the West Coast because they might conduct sabotage or espionage. And so they were removed, given the choice of either leaving under their own volition or they were removed. And this was the alien land law's ultimate fulfillment, because it meant that all of that land, all of that property that people had been coveting and you know, trying to displace Japanese Americans by using alien land laws had now been was now, you know, could be taken over, right? And so not that many Japanese Americans were able to recover their property and return. Now, no evidence of espionage or sabotage connected to Japanese Americans was ever uncovered. Furthermore, you know, in the 1970s, 1980s, through efforts of the community, the smoking gun was uncovered that, in fact, you know, military experts had actually looked at this issue and had in fact determined that there was no military necessity. There was no reality that Japan in fact could muster the sort of the Air Force or the Navy, you know, wherewithal to attack the West Coast of the United States. Hawaii was different, but the West Coast of the United States was not vulnerable. And so the whole justification for incarceration, in fact, was false, right? And so the vacating of the Supreme Court cases, the congressional apology to Japanese Americans rests on this, you know, acknowledgement of these lies, sort of the racial animus that that sort of underpinned those lies, and you know, and so as we see what's happening here, it is in fact very, very frightening. And this claim of national security, it has not been explained in any way, to my knowledge.
Can I add one quick thing? Just as Professor Hu said. Just like in World War II, where the military experts say, hey, we've already got this covered, this is not necessary, right? This is just meaning this is political, not a policy issue. In the same way, right now, for all foreign investments from any external element, we have in the federal government a group called CFIUS. And this is a Committee on Foreign Investments that reviews all foreign investments in the United States. And this is an interconnected committee that has close ties to the FBI, CIA, NSA, DOJ, State Department, and they all work together to sort of like, to basically see if the investments in the United States are problematic for national security or for other reasons, right? So all these, if there are investments, there are purchases being done in the United States, they're already being reviewed by the federal government and by people with actual knowledge, right? So the question is, what does Texas do? What does the state of Texas actually do in terms of national security? Do we have an NSA? Do we have a CIA or an FBI or a military intelligence or a State Department? What is the basis of Texas doing national security? Not to say that national security is not important, but if you're going to make this judgment that certain people shouldn't own property in the state, what is the basis of that judgment? How are you making that decision? Or are you just saying, well, anybody with yellow skin and slanted eyes, shouldn't own property? That makes, that's the alternative.
So many echoes of the past. And I think that's what these 1882 talk story conversations often raise, is that many issues that a lot of what Professor Xu is talking about, actually, we hear the same kinds of rhetoric today as were so prevalent in the past. There has been a question about, are there copycat laws? We know that 14 states actually already had some restrictions, not total restrictions, but some restriction on foreign ownership of property and land in the US. But there are, I think, 11 state legislatures that are considering measures like this. And so, I see this as kind of a real kind of tumbleweed of legislation that I think it's really important to have this conversation. I want to turn to Professor Suzuki to talk about so what we're hearing is there was, you were part of a group that drew attention to this issue, partly through your own advocacy to get this law off the books. Let's talk about the political climate a little bit. Was there pushback to your efforts to get it off the books, or did you see people sort of maybe unaware of this law and it was an educational opportunity? Beyond just getting it off the books, what other kinds of political ramifications did you see, or what kind of pushback were you receiving?
So when we went forward in New Mexico, we were trying to follow the other states that had managed to get the alien land laws out of their books. And so, as I said, it was just us in Florida. So apparently the attempt that occurred before I got to New Mexico failed in part because of the way that the referendum was written. And the referendum has to follow and use the language of the constitutional provision, which talks about aliens. And so I think since we are a border state with Mexico, the failure the first time really had to do with people fearing immigrants. It's just, that's what it is. Oh, aliens. And there wasn't enough education to say, well, this law actually is not being used at this moment because there's a violation of federal law. We're just trying to get rid of this provision that is really race-based. So when the students and I attempted to get the resolution passed and the vote back before the people, we really did have to do a lot of education because we're still stuck with the terminology. So we still had alien in the resolution because that's what we had to work with. And a lot was the education that it's not about immigrants. This is really a racist provision, something that remains on the books that is no longer used. So it was political in that we really did have to do a lot of education that we're not talking about immigration, which is an ongoing concern in New Mexico and other states.
Thank you so much. And I'd love, we have about 15 minutes left. So if you have questions, those of you in the audience, please feel free to post them in the Q&A. I think there is an interesting issue here that we can all discuss, which is Representative Wu mentioned another bill has been introduced that you support that achieves the same sort of security goals, but does not include nationality. And at the same time, I think Professor Xu was talking about this fact that you can actually introduce a law that doesn't reference nationality, but still does have discriminatory effects. And yet there is this kind of, so I think that's a little bit of a tension or something to think about. But maybe both of you can talk about this this alternative approach and efforts to not use nationality and still achieve these national security goals. Do either of you want to chime in here?
Oh, I can offer up maybe a couple of comments. One comment is that formally, according to the Constitution, foreign relations are a matter of federal authority. And so as Representative Wu was pointing out, discussing on a granular level, right, the state government of Texas, any state government, in fact, does not have grounds, much less the capacity, the personnel, the expertise to, in fact, enact legislation claiming that it's in the interest of national security. So there's that. If you actually wanted some sort of law that was trying to ward against actual threats to some sort of security issues, then you target the actions, right? So what are the actions that might have these sort of dire implications or lead to possible problems? You target the actions and using sort of national background is in fact an incredibly poor mechanism for identifying threats, right? And if you actually are going to do this kind of legislation, you should actually have a very clear understanding of connecting all the dots of why this particular set of restrictions then is necessary, or can significantly actually attain this goal of protecting Texas or U.S. interests. So that was what I was thinking about. I can also add that for most of the time that the United States has been regulating immigration since 1882 up through the present, most of the time the primary criteria has been race and national origin. So up until 1965, U.S. immigration law was in fact heavily discriminatory, just starkly favored immigrants from Western and Northern Europe. And some of the pressure to retreat from that, to dismantle that, one, it impedes U.S. foreign relations. It makes clear to other countries and other peoples who the U.S. looks down upon, regards as less assimilable, not welcome. But it's also, in very practical terms, a very poor gauge of figuring out what persons would be good immigrants, what people really sort of are interested in making a significant life for themselves and their, and their descendants in the United States, what people bring certain kinds of skills and expertise and work capacities. And so this whole use of nationality to identify potential threats or problems is, fundamentally racist. Right. I will just say, I'm not sure if the representative, the senator who proposed it is thinking in those terms, but it reflects a racial way of categorizing people.
Thank you so much. Did you want to add anything, Representative Wu?
I think Professor Hu covered it pretty well. But I want to add this, add this point is, I think this is, I think in all our discussions about this is obviously a type of thing that our community has fought against for since there was such a thing as Asian American. That in the historical context of our community, since there were Asian immigrants to this country, we've been fighting off this idea that Asian Americans can never truly be American. That Asian Americans are somehow inherently more unable to be assimilated, and can never truly be a part of this country, can never truly be loyal, can never truly be red, white, and blue. And so, I think the way I talk about it is, if I say like, have you ever been asked the question, people ask you, where are you from? And they always, you tell them, I'm from Houston. And they always immediately follow up with, no, where are you really from? Right? Every single Asian person has had to answer that question. And while the person asking the question may really be asking for ethnic identity, the way they couch their question, speaks of this inherent inherent disbelief that Asians can be American. This idea that I don't really believe you when you say that you're from Texas. Even though like my kids will be born and raised in Texas, but somebody is gonna challenge them when they say I'm from Texas, right? And this is something that we've struggled with. And I mean, just to get on my soapbox just a little bit, but this is also why I hate the myth of the model minority. And I know that's something that I know some of our elders, especially my parents, really push this idea that Asians are different. We're the good minority. We don't complain. We don't protest. We just work hard. But that also means that there's something wrong with you. Somehow you're different from all the other people. You're different from regular Americans who would complain and would protest and would speak up if our community was harmed. And that because they give us a little pat on the head, oh, you're the model minority, you're the good ones. But it also means that you're somehow different from everyone else. You're different from the other communities. You don't do all the things that we expect Americans to do. And we end up reinforcing this perception that we're different, that we're somehow, strange and unusual and, never really part of this country, because real Americans protest. Real Americans get pissed off and yell angry things at their elected officials, right? No matter if you're Black, Hispanic, white, or whatever else, but somehow the Asian ones are just different. I mean, they say, "Oh, you're the good ones," and not right now, but I think maybe in the future discussion, our community needs to address that. Our community needs to address this idea that we're better, we're somehow better because we don't speak up, we don't protest, and we don't get angry, we don't take action like what we're doing now.
And of course, there is a long history of protest in Asian America, both legal and in other respects. But there is that stereotype, the model minority stereotype that you're talking about. And it's always there with its cousin, the forever foreigner stereotype.
Right.
We have a few more minutes and some questions have come in. One is about other kinds of restrictive kinds of practices, like restrictive covenants that were allowed to be on the books and that were, race conscious in that way. Another question, so that's one sort of theme, is the other ways in which nationality origin can be used and has been used historically, not just in owning property, buying property, but also who can move into what neighborhood. The second set is really on the slippery slope question and whether this legislation, you might expect it to spill over. And I think that goes to maybe Professor Suzuki. Are you, in the law and in your legal communities, are you seeing attention to this as a potential slippery slope?
I think there's always a possibility of that, right? If we're grounding national security on owning real estate, are we also going to ground national security on different types of jobs that people have? STEM positions, for example, or even faculty STEM positions. Should people not be working at our national labs? So yes, there is a slippery slope that's possible. And also in regard to SB147, faculty member trying to teach at a particular school might not be able to own a house near that school. So if somebody does want to make an investment and is only able to rent, perhaps that person won't take that position. So it certainly can go from owning real estate to being discriminated against in jobs. Yes.
And I think this is the question that is kind of in the background, and it's from a participant, Veronica Lee. Will this Texas bill or other kinds of bills that are similar do those kinds of national origin, nationality call outs in the legislation, in that proposed legislation? Does that violate the Constitution?
So I have not done a deep study on this, but I do know that the Supreme Court in 1952 found the state alien land laws to violate the 14th Amendment of the Constitution.
So it might depend on the composition of this court in some ways, right? Okay, Ted.
Okay, so we're heading to the 7:30 mark. We can actually stay longer if we want, but I know that a number of people need to get off, and that's okay too. But there are a number of issues that we might want to unpack. And I like the idea what Jean was mentioned, that the model minority does a lot of harm for us, right? Because, and I don't necessarily agree that we have always been silent. The question has been, what have we done to bring people's attention that we weren't silent? Whether even as early as the construction of the railroads or any of these other laws that we've done. I think that there's been a lot of effort to address immigration laws, of course, but any of these other things. And that's part of what the 1882 is about, is trying to take these stories and bring them up so that we tell our own stories in our own ways. And that's important. Now, what Jean has said a number of things, and everybody else has amplified too. It is not just this property law. It's not a slippery slope because it already is slipping. Jeremy and the APA Justice has spent how many years working on the FBI initiative, which is actually limiting people from places like STEM programs and things like that, because they are Asians, or there's an automatic suspicion that they are disloyal or possibly disloyal to us. And this is where Jean is absolutely right. The issue about these sort of visible laws. Now, let's give you a background. I actually work at the Department of Immigration and Security issues too. There is a reason to watch out for theft of technology, or commercially or security-wise. But it is not through these type of public laws, FBI or alien land laws, because they do exactly what many people have said. They have a they have an effect on we're collateral damage. So they're saying if the FBI director says it has to be an all of government approach to making sure that our technology is not stolen in laboratories or things of this sort, or then those people who are not trained security people will then discriminate on what is apparent to them. And that's us, the way we look. And that's a problem that we have to be concerned about. So I just add that to that. And any other comments? I do want to congratulate people like Stephen Pei, Haipei Xu, Jeremy, and the APA Justice for bringing so much attention to these issues.
Thank you so much. I want to just throw it to our panelists one more time. Is there any other, Professor Xu, do you have another, any last comment you would like to make?
Oh, I was just going to make a pitch for May Nai's wonderful book, The Chinese Question, which looks at Chinese gold miners, the gold rushes in California, Australia, and South Africa. And she had to work really, really hard to find these stories, right? But from the 1850s in California, Chinese merchants, Chinese people were very well informed about US laws, about how the political system worked. You had leaders who were bicultural. They went to Sacramento and they protested. They wrote letters in as you know, California was already starting to enact its anti-Chinese legislation. So this has been, you know, so Chinese Americans, other Asian Americans have been deeply, deeply informed, and they, you know, they have just have always engaged with American political processes and institutions to try to advocate on their own behalf. What was held them back was that they could not get citizenship, right? Most people could not get citizenship. They could be easily dismissed, you know, but things are very, very different now. And you know, and Representative Wu mentioned this. I think, you know, in Texas, legislatures are a little bit taken aback, but they are realizing that, you know, the Asian American community has become very, very well organized and very vocal and won't be pushed around, right? And so I think they had probably been also acting on assumptions about being a quiet model minority. And, you know, and I'm really, really so grateful to see that how powerfully they've been proven wrong.
Thank you so much. And I want to thank our panelists for their participation. So many really wonderful perspectives, and it's really inspiring to see the activism on the ground in this very informed way. So thank you to Professor Suzuki, to Professor Xu, to Representative Wu, and to the 1882 project. We're going to close out the formal portion of this webinar, but those of you who can stay on are welcome to stay on, and those of you who need to go, thank you so much for joining us, and we give you a virtual applause.